Let's go ahead and go on the record on cause number DC 23-16558, Callaway versus Baylor Scott and White Health. Council, make your appearances.
Ronald Dupree on behalf of the plaintiff, Lawrence Callaway.
Simon Whiting on behalf of Baylor Scott and White Health.
All right. We have a motion for summary judgment that's been filed by Baylor Scott and White Health. You may proceed. I've read all the briefing.
Thank you, Judge. Judge, last time we were here for a hearing was on the motion to transfer that venue, and you predicted that we'd be here again on a motion. And as you predicted, here we are, and this is the motion. There is one statutory cause of action that is alleged against the defendant in this case by the plaintiff, and it's under section 164.134 of the Texas Health and Safety Code. It's the sole statutory cause of action that is pled against my client. This case, Judge,
I'll do it just a second. Here you go.
This case revolves around the language of the statutory provision. And the highlighted portion here indicates that a hospital, mental health facility, or treatment facility may not suspend or terminate the employment of, or discipline, or otherwise discriminate against an employee for reporting to the employee's supervisor, an administrator of the facility, a state regulatory agency, or a law enforcement agency, a violation of law, including a violation of this chapter, a rule adopted under this chapter, or a rule of another agency. The critical language in the statute are those first few words. My client is not a hospital. My client is not a healthcare facility. It's not a mental health facility. It's not a treatment facility. The statute simply doesn't apply.
So obviously the issue here is kind of an issue of business, how the business is organized. Baylor Scott and White, I guess, has a number of hospitals across the state, correct?
That's right, Judge.
Including one in Marble Falls, is that right?
That's right.
And this is against the Baylor Scott and White Hospital or this gentleman worked for the Baylor Scott and White in Marble Falls, correct?
That's our position, Judge.
Right.
Their position is that he worked for Baylor Scott and White Health, a corporate entity out of Dallas. That's the reason that we had the motion to transfer venue, and they were claiming that that was his employer. And Baylor Scott and White Health, being here, is one entity. The Scott and White Hospital in Marble Falls is a separate entity.
According to the plaintiff, Baylor Scott and White Health, which is the defendant in this case, is a DBA of Baylor Scott and White Marble Falls. Is that correct or not?
Yeah, and I'll show you those. Those are attached to the response to the summary judgment motion. I mean, his argument is that Rule 28 should apply here. I mean, that's basically what he's saying. But it's a red herring. And the reason it's a red herring is exactly what the court said at the end of our hearing on the motion to transfer venue. And that is that this is not a misnomer case. This is a misidentification case. These are two separate entities, and the entities have different purposes, all of which was in evidence at that hearing for the motion to transfer venue, and again here. And I'm going to show the court exactly what I'm talking about.
So one of the confusing points about this, because this has happened in a couple of cases involving Baylor Scott and White lately, is as I understand how Baylor Scott and White is organized, is there's just one company, Baylor Scott and White, and each of these different hospitals are not different entities, correct?
No.
That are all part of Baylor Scott and White.
Well, there are two different pieces there, or they are not. They are all separate entities. There are well over 100 separate entities that are part of the sort of Baylor family, if you will. Baylor Scott and White Health is one of those. And what it does is sort of corporate administrative type functions. So it provides legal support. It provides some sort of HR support, things like that. We listed those. It is in the evidence.
So
before you.
what is the corporate relationship between Baylor, Scott and White? Big Baylor, Scott and White in each of the different hospitals? Is it a parent company? What is the relationship?
It is somewhat apparent, and I'm not going to misspeak because I know it's complicated and I haven't got all of the picture as to, how all the various pieces are fit together. I have at one point in my career seen some sort of a listing of how many companies there are.
I'm
but
not
how
asking
they fit
for,
in.
I'm not asking for every single, I'm just really asking, what is the relationship between Baylor, Scott and White Health and Baylor, Scott and White Marble Falls?
Baylor Scott and White Health provides administrative support.
Is it a parent company or is it a separate entity?
I don't believe that it is, but I also don't want to misspeak.
Because what's confusing is that according to what the plaintiff has submitted, is that Baylor Scott and White Health is a DBA doing business as a Baylor Scott and White. But then you also say it's a separate entity as well. It's a little confusing about what is the corporate structure here and how are they related to each other?
I agree, Judge. And so I can show you from what they submitted in the response in opposition to the motion to transfer venue, insofar as it talks about what Baylor Scott and White Health does. And this is the one I'm referring to. This should be Exhibit A from.
Yeah, I don't have the documents on the transfer venue.
I'll put it on the Elmo, Judge. I mean, it is part of the record in the case.
Okay. I'm not necessarily going to consider it because it isn't part of the summary judgment record, but.
So this is the restated certificate of formation that was put in.
For Baylor Scott and White Health,
Correct.
The overall company, okay?
Well, this is the name and it tells you what the purpose is. And the purpose here is that it's organized and shall operate exclusively for the benefit of, to perform the functions of, or to carry out the purposes of, and it lists a whole bunch of hospitals, all of which are separate entities. It goes on over the page after it lists those various entities.
Is Marble Falls one of those entities?
It is, Judge. And in essence, what it does is exactly what the affidavit that I've got submitted as part of the summary judgment evidence in this case. And it's providing management and administrative services for these entities. So it's not doing, the actual patient care or, hospital type work. It's doing the administrative parts, finance, accounting, legal, human resources, risk management, quality, and information services. So that's basically what this company does. Now, the other piece of this is what is part of this, which is submitted as P in the response, is the assumed name certificate. So this is the assumed name certificate for Scott and White Hospital, Marble Falls. And it tells you there that the assumed name is going to be Baylor Scott and White Health here. But the name of the entity is Scott and White Hospital, Marble Falls. It is a separate entity. It has a principal office in Temple, Texas. Now remember, Baylor Scott and White Health has their principal office in Dallas. And that was the basis of the venue motion. It's also all the way through the pleadings. So the original petition that was filed in this case specifically sued that entity with a principal office in here in Dallas, which is why we're here. When we filed our answer and motion to transfer venue, we stated, this is the wrong party. This is the correct party, and we named it. We filed our motion to transfer venue. They filed their motion in opposition, maintaining that no, Baylor Scott and White Health was the correct party all the way through. They then filed an amended petition in December. Same thing, just the Dallas entity. We had the hearing in February. At the hearing in February, you denied the motion to transfer venue, maintain venue here in Dallas, based on Baylor Scott and White Health with its principal office here in Dallas. This is a separate company. This is the correct company. We've maintained that he was employed by this company. They maintain that he was not. In their affidavit, in this case as well, plaintiff says, I believe that this is from Exhibit A to their response to the summary judgment motion. This is Mr. Callaway's affidavit, Judge. And he says that he was employed with Baylor Scott and White Health. And while he was employed by Baylor Scott and White, he was assigned to Scott and White Hospital, Marble Falls. He's clearly making the distinction. These are two separate entities. The proof before you shows that they're two separate entities. And, you know, they have consistently maintained and argued that the correct entity is Baylor Scott and White Health, a corporate entity in Dallas. And that's the basis of our motion. That particular corporate entity is not a hospital. It's not a treatment facility. It's not a mental health facility, and therefore it's not subject to the statute. So respectfully, Judge, we ask that you grant summary judgment.
All right, response?
Well, Your Honor, I prefer to focus on the standard in this hearing, which is the summary judgment standard. And that standard requires the court to take as true all evidence that's favorable to the non-moving party and to indulge all reasonable inferences in favor of the non-moving. Now, this particular motion would turn that standard on its head. The defendant's motion admits, and Mr. Whiting has already admitted today, that the plaintiff was employed by a hospital, Scott and White Hospital, Marble Falls. This is a hospital within the meaning of the statute. Now, the issue here is that Scott and White Hospital, Marble Falls, filed an assumed name certificate with the Texas Secretary of State. They said, we're going to do business as Baylor Scott and White Health. That's why everything identified for the plaintiff throughout the life cycle of his employment says Baylor Scott and White Health. That's not really in dispute. He was employed by a hospital. It says so in their brief. It says so in their affidavit. The issue is that when Scott and White filed that assumed name certificate and continued to do business under the name Baylor Scott and White Health, they availed themselves of the statute. They availed themselves of Chapter 28 of the Texas Rules of Civil Procedure, which is clear and states that an entity doing business under an assumed name may sue or be sued in the name of that assumed name. And you know, this has been confirmed by the Texas Supreme Court in the cases cited in the brief, 6 SMA Partners and Hyson. The Texas Supreme Court has also said that the use of an assumed name is a fact issue, right? And if we look at the evidence and the record in this case, the defendant used the name Baylor Scott and White Health throughout the life cycle of Mr. Callaway's employment. For example, in Exhibit C of the plaintiff's brief, in the offer letter, they hired Mr. Callaway using the name Baylor Scott and White Health. I'm gonna put it on the Elmo just so that it's in the record.
You're upside down.
This is Mr. Callaway's offer. Clearly, top left-hand corner, Baylor Scott and White Health. The job description. Baylor Scott and White Health. During the plaintiff's employment, how he was evaluated, whether or not he was doing a good job, his clinical competency. Baylor Scott and White Health. During his employment, to review and to provide Mr. Callaway with awards. Baylor Scott and White Health. When they requested to suspend Mr. Callaway. Baylor Scott and White Health. In fact, the last document confirming his termination. Baylor Scott and White Health. Now, what does all this mean? Well, the Supreme Court, in the cases cited in the brief, Your Honor, states clearly that the use of letterhead, the use of marketing materials, demonstrating the use of an assumed name is evidence that would demonstrate that that party can sue or be sued in its assumed name. And that's what's happened here. And because the Texas Supreme Court has confirmed on multiple occasions that a party can sue or be sued in its assumed
I
name.
guess kind of I get what you're arguing. It's Baylor Scott and White doesn't make this very clear. It kind of feels like either this case, it seemed like the motion transfer venue, you were claiming there's two different entities. There's Baylor Scott and White, there's Baylor Scott and White, Marble Falls. Now you're basically claiming there's just one entity. Or are you claiming there's one entity?
Well, what I'm saying, Your Honor, is that they have confirmed in filing an assumed name certificate and operating, utilizing their assumed name, they've confirmed that this entity, Scott and White Marble Falls, is going to do business as Baylor Scott and White Health. And by virtue of making that declaration, unprompted and untethered to this case, they have represented to the world and honestly to this court that they're going to do business as Baylor Scott and White Health, and that allows Mr. Callaway to sue them in their assumed name. So I'm not necessarily saying that they're the same entity. I'm saying that they have represented to the world that they're going to do business under this assumed name, and the courts have tackled this issue. They have identified factors that can be used when a party represents itself under an assumed name and allows itself to be sued under that assumed name. And so that's the argument for both the first element of his retaliation claim and for the fifth element, which basically means that he was terminated by a covered entity. And just to reset, Your Honor, this is a summary judgment motion. This motion requires all inferences to be resolved in the favor of the non-moving party. And in this case, Chapter 28 makes it clear what would be appropriate if the court sees fit, which will be to order the party in interest to change the name on the case itself.
Wait, say that last part again.
So Chapter 28 of the Texas Rules of Civil Procedure says if on a motion, if the court is so inclined that it can order the party, the real party in interest to be named. The true name of the defendant in this case. That's the remedy, is what I'm saying.
All right, response. Go ahead.
Thank you, Judge. Just briefly, we did what any good defendant would do right from the get-go. We told him exactly who the right party was. We answered on behalf of exactly the right party at that point. We told him, Scott and White Hospital, Marble Falls, DBA, Baylor Scott and White Medical Center, Marble Falls, incorrectly named as Baylor Scott and White Health. We told them that right from the start. We did that through the motion. They have maintained every time that we've run into this issue that no, the correct party is actually Baylor Scott and White Health. That's what they used for the basis of the venue motion. Now they're taking completely inconsistent positions. And they're saying, oh, no, we didn't really mean that one. We really mean the other one, which means that we shouldn't really
let's
be
look at Rule 28. And it says suits and assumed names. Any partnership, unincorporated association, private corporation, or individual doing business under an assumed name may sue or be sued in its partnership, assumed, or common name for the purpose of enforcing for or against it a substantive right, but on a motion by any party or on the court's own motion, the true name may be substituted. And so it would, I mean, so it would seem like the proper remedy here would be, for me, I can do this on courts of motion. I'm going to order you to, under Rule 28, to substitute the true name of the corporate entity that has been sued in this case. He hasn't done anything wrong by suing under the assumed name. I mean, it's kind of Baylor's fault that they don't have, like, I don't know why Baylor Scott and White Health isn't called Baylor Scott and White Health LLC or Inc. or whatever, but they decided to incorporate under this name. I can see why there's a confusion. So I'm going to order you under my own motion to substitute the true name, and then at that point bring a summary judgment and then summary judgment at that point. Okay.
Okay, Judge.
Okay,
Thank you, guys. Have a great rest of your day.
thank you.
Thank you, Judge.
All right, Miss Murillo, are you there?
Yes, Your Honor, I'm here.
Are you here for the default judgment here on the Garcia case?
Yes, Your Honor. I don't have my client with us today. I tried to reach him multiple times and we haven't been able to. However, we did file all the affidavits with the court.
You guys have a great rest of your day.
Thank you.
Thank you, Judge.
Let me see what you filed. Let's see. When did you file all the affidavits? Was that,
We filed the medical affidavits on May 31st, if I'm not mistaken.
or May 29th? Let me see.
Yes, May 29th.
Well, you have a couple options here. You have until 7/22. If you want me to reset this hearing to next Friday, you can, and then try to get your client here. You can have them testify about pain and suffering and all that kind of stuff, all the soft damages, or I can just enter a default judgment on the medical today. What do you prefer?
I would like to reset, Your Honor, if that's possible. And would you be okay if I do it by submission? Because I
Nope.
think the problem with
Nope.
my client is that he is at work and I don't think he has the opportunity to miss work to come to the hearing.
I mean, just on Zoom, you should be able to take 5 minutes to do this. So let me say this again, because I don't think I probably wasn't very clear about this. So you're gonna have to have your client testify if you want to have pain and suffering damages on your default judgment. So if you want that, then you'll need to have him testify. If you don't want that, I could sign the order of default judgment right now. There's no reason to take it under submission, right? Because
Right, no, I understand. Can we just reset it for next Friday then? I'll try to make sure that my client shows up.
all right. You don't want me to just enter the default judgment for 12,000 right now? So, okay, I'll just reset it for a week. So reset this to next, Rhonda, are you there? Rhonda, are you there? Rhonda, are you there? Oops. Oh, Rhonda's not on anymore. Never mind. Okay, I'll just tell Rhonda. And you have a great rest of your day, Miss Morello.
Thank you, Your Honor.
Thank you. And that'll be next Friday at 11 o'clock.
Okay, will do. Thank you, Your Honor. May I be dismissed?
And then understand that if they don't show up, you have a DWAP the next Monday. So you need to, if they don't show up, you're kind of
Kind
Just
of
gonna
forced
have
to
to-
take it on just the medical, I think.
exactly.